Imagine you've just inherited your grandmother's cozy little cottage by the lake, the place where you spent countless summers learning to fish and watching sunsets. But amidst the nostalgia, a pressing question arises. How do you officially transfer this cherished piece of real estate into your name? Transferring real estate to heirs is more than just a legal procedure. It's about continuing a legacy. At its core, this process involves ensuring that ownership is smoothly passed from one generation to the next. Typically, this can happen in a few ways: through a will, a living trust, or, in some cases, through joint ownership arrangements. Each method comes with its own set of rules and nuances that can vary from one jurisdiction to another. It's crucial to understand these differences to avoid any hiccups along the way. Let's delve deeper with an example. Picture Sarah, who recently lost her father. He owned a charming Victorian house in the heart of the city, a place brimming with family history and memories. Her father had prepared a will, clearly stating that the house should be passed on to Sarah. This is where probate comes in, a legal process that validates the will and oversees the transfer of the property. While this can sometimes be a lengthy and complex procedure, having a clear will can significantly streamline the process. Imagine Sarah working with an attorney, navigating through probate court, ensuring all the necessary documents are in place, and eventually walking through the door of her father's home, now legally hers. Alternatively, if Sarah's father had set up a living trust, she could have bypassed probate entirely. A living trust is like a treasure chest where assets are placed, and upon the owner's death, the designated trustee distributes these assets to the heirs. This route often saves time and can help avoid some of the costs associated with probate. Imagine Sarah receiving the keys to the house almost immediately after her father's passing, sidestepping the usual bureaucracy. It's also worth considering another scenario: joint ownership with rights of survivorship. If Sarah had been co-owner of the house with her father, she would automatically inherit his share upon his death without the need for probate or trusts. However, this arrangement requires careful planning during the property purchase or a subsequent deed change. Reflecting on these approaches, it's clear that planning is key. Whether it's through a will, a living trust, or joint ownership, each choice has its own advantages and potential drawbacks. It's about finding the right match for your family's unique situation. More importantly, it's about ensuring peace of mind, knowing that your family's legacy is secure and respected. The real estate you cherish can continue to be a source of joy and connection for generations to come, just as the lakeside cottage remains a sanctuary of family bonding. In the end, transferring real estate to heirs is not just a legal formality, it's a thoughtful act of love and foresight, a way to keep the stories and memories alive.